Okay. There was I'm just going to jump back one step because there was a case which I meant to speak about. It's of interest to certainly the bar out here. It's called Bedrosian. It came out last year in September of 17, and it's actually in the Third Circuit here. It's actually the first taxpayer win in the FBAR area. So we're kind of going back a little bit to the program. Remember I talked about willful FBARs is a 50% penalty, and that's if you get picked up. Bedrosian, you have to remember how the IRS operates, and again, I was part of it, so I certainly was at that time part of it. The service has a national presence, so when they choose to litigate cases, they usually take, or they try to take, the cases with the best facts from the government's point of view. And if they have two cases with the same issue, well, they're going to try the one with the best facts. And so in the FBAR area, the penalties are very steep, as you can imagine. And there's very little case law right now. There are a bunch of cases in the pipeline because of the prevalence of the programs. But the numbers are usually very high. The penalty numbers are very high, so it makes the litigation more feasible, more plausible. The two cases that have been out there for a while now in the FBAR area, you basically have taxpayers get pigs. That's the way it is. One of the cases, there's two cases, one called Williams, one called McBride. And one of the taxpayers who litigated, I mean, these are clear income tax evasion deals overseas. Now, one of the cases, the guy actually in his allocution and pleading guilty pled. He was tax fraud all over the place. He, in his allocution, talked about hiding the accounts in Switzerland knowingly. So those are not good facts, and they actually came down pretty much on top of him in the two court cases that are out there. And the service uses them extensively. When you get bad cases, you get bad law. And again, the service is picking the cases which are best for them to litigate, which is something I used to do when I was with the government. We always take the case that's best for the government, especially on the same facts. And both of these cases, in the dicta of the judge, which is the part that the judge is narrating, basically says, you know how you sign on page 2 under penalties of perjury I've read, and you know the language you see on the bottom of the returns? Well, that applies to Schedule B, which is the part where you're saying, do you have any overseas accounts? You might be subject to filing an FBAR. Both these guys checked no on the box. But the general excuse is, well, I never read it. The accountant gave it to me, so I signed it. But the problem, of course, is, in the judge's opinions here, they attributed knowledge. You know, if you sign the return, you're attributed to the knowledge of what's on the return. And if you had read the Schedule B and that little language on the bottom of the Schedule B, you know, subject to FBARs and the way it's worded, they said you're charged with knowledge. So you had to know. That's part of what's in those opinions. And I would go to a lot of these appeals. We would represent people in IRS appeals or with the agency, and we were always getting hit over the head with these two cases. And they were very typical in all the appeals we did. Well, have you read McBride? Have you read Williams? And, you know, you're charged with the knowledge. So we'd always hear that. And so it was very hard and very difficult to get a revenue agent's determination of a willful FBAR penalty overturned. And as I said, in September of 17, out comes this case called Bedrosian. And it's the first taxpayer victory in this area. And so the IRS appealed it. But anyway, the case of and it got remanded back to the district court just recently, just a couple of weeks ago. But the facts of the case are, this guy's a pharmaceutical guy, and he's working overseas. He does a lot of traveling. He's actually he's the chief executive officer, I believe, of the company. And he starts, a very long time ago, he starts a bank account in what was the predecessor to UBS in Switzerland. And all of these years, he's not reporting any of the income from this Swiss bank account. And he finally fesses up to his CPA. His CPA tells him, you know, again, it's in the opinion. I can't tell you whether it's right or wrong, but It's a finding of fact. The CPA tells him that you've been breaking the law all these years. But don't worry about it. When you die, your estate will fix it. And this goes on for more years, so he's not reporting anything. And then, lo and behold, the CPA dies and he gets a new CPA. And now we're into 2007 and 2008, 2009 in that area. Again, what's going on with UBS, they're kicking the Americans out, and the information is being turned over and stuff like this. And he gets this new CPA. And for the first time on his 2000, I believe it was his 7 return, the F-bar box gets checked on the Schedule B. Still doesn't report the income, but the box is checked. First time. And then more stuff is coming out on UBS, and he gets worried. So he goes to see his personal attorney, who then refers him to a tax attorney. And the tax attorney recommends that he amend all his returns. Okay? And he then files the F-bar. The only problem was the F-bar only reported one of 2 Swiss accounts. He reported the smaller account, I believe it was a couple $100,000, and he left the $2 million account off the F-bar. The service picks him up for audit a couple of years later, and they start auditing him. He's cooperating with the agent, doing all the right things, that's in the opinion. And apparently, if you go way back into the pleadings of the case and some of the court papers, the service initially recommend a non-willful F-bar penalty, so that's $10,000. That's the non-willful penalty. The willful penalty would be about 50% of $2 million, so you can see the big difference in the numbers. And even though the agent, the original agent, recommended no willful penalty, the service bounced it and reopened the case and charged him with an F-bar penalty. This gets litigated. That's essentially the facts. They're a little different, but that's essentially the facts. And it goes to trial. And the court in Pennsylvania, which is part of the Third Circuit here, it's a district court, says non-willful. No F-bar penalty. That's what the district court said. And on those facts, basically on those facts. And the standard in a willful F-bar case is you have to have intentionally known, or you have to be reckless, of which, reckless disregard, the willful, blindness. That's essentially the standard in the case. The service has to win by a preponderance of the evidence, but that's essentially the standard, and the taxpayer wins. Because the court turns around and says, well, he may have been negligent, but I don't think he was willful. That was a bad opinion for the service, so the first thing they did was appeal it up to the Third Circuit. And then oral arguments were held, and then a couple of weeks ago, the Third Circuit came out and remanded the case back to the district court because the Third Circuit thought that the district court did not use necessarily the proper standard for willfulness. Okay, so the case sits now on remand. That is a big taxpayer win if it stands. And no one knows if it's going to stand yet. That's Bedrosian. So all the people that practice in this area, like myself, everybody's watching in this case. Okay, got to remember, the case law is very, very bad in this area for taxpayers. We've got a bunch of cases in the pipeline, actually. We have one going to trial, assuming the government stays open and it's not affected. But we have one going to trial pretty soon on a willful F-bar penalty. And we got a bunch in the pipeline that we're anticipating trying. And it's not just us. There's going to be other attorneys, so there's going to be a lot of case law coming out on this soon. But that's Bedrosian. That's a big case out here. So I just want to move on a little bit. How about this? I always like these cases because they're fun. Everyone know what 100% penalty is? Responsible officer provisions in the Internal Revenue Code. There are certain taxes in the Internal Revenue Code, like withholding from the employee, the FICA piece of withholding on the employee. They're trust fund taxes under the Internal Revenue Code. And if they're not paid over by the employer, the responsible individual is personally liable for this stuff. And that's a big problem for the government, getting a handle on this, especially in bad economies, because most people that we've seen, they really do try to pay it back, and it's kind of like a loan. They kind of think they'll get it, they'll pay so they got to pay their employees for their inventory, they got to do all these expenses, they got to pay their landlord. And the government, they kind of borrow on, because it takes a while for the government to catch up on this stuff. That's called, but that's where you see the personal liability to individuals. And you can lose your house, your bank accounts, your stock account. There's a whole slew of stuff that you can be levied on in the Internal Revenue Code. And that's a pretty damning provision in the code, because it does affect a lot of people. And as I said, a lot of people, it's kind of like it's like a lawyer's trust account. If I dig into the trust, this is how the IRS will view it. If a lawyer like Jay or somebody were to dig into their trust account and take the money, but meaning to pay it back, I mean, you're going to lose your law license for it. And it's kind
Just
of,
so that people know, it's a 6672 penalty.
yeah, it's a 6672 penalty. And there's three provisions that have to basically come together concurrently for you to be a responsible individual. So you have to be an individual, which over the years has been defined to be basically anything. It could be a CPA, in fact. In our case law, where the CPA got too close to the business, and so the CPA was held liable. But it can be a surety, it can be the CEO, it can be the CFO, it can be more than one person, in fact. In fact, the government will always try and get more than one person involved, because what happens is if you get more than one person, then you can legitimately, a bona fide, get a responsible officer assessment against, you got more chance of collecting it. Also, if it were to go to trial for some reason, it's good that you have everybody pointing the finger at everybody, so you have one person sitting in one chair saying, he did it. You have the other person saying, no, I didn't do it, he did it. So you have all kinds of people pointing each other, which makes a great case for the IRS, at least from the IRS's point of view. Which brings us to a case that came out of Newark, the place I work in. It was actually in my office when I was there. And I read it because the dictum in the case is really, the court writing it up is really pretty funny. So what you have is, you have a bunch of do-gooders. They were interested in helping the people in Newark. And they were running a whole slew of services like healthcare and other stuff, recreational. And to be fair, the individuals were, at various times, held various positions inside the company, but there were many people who were directors. And these guys held, again, the service trying to get to the people who can pay it, right? If they can't collect it, it's just a waste of time. So they try and get the people that are responsible, but also the people that can pay it. And so this case comes through the office. And again, you have to be an individual. You have to be a responsible individual, meaning you have the duty to pay it over, and you have to be willful. So those three items concurrently coming together will cause an individual to get the responsible officer provision, and the assessment individually, as will the business, but the individuals are ones will generally wind up paying it. So that's the background to this, and I always get a chuckle out of this case because of the way the judge wrote up the opinion. He wasn't too pleased with my office. And so I wrote down, I just a bunch of index cards. I wrote part of his opinion down, which I always find kind of funny. And he says in there, this matter, I'm going to read it to you. This matter portrays the government at its heartless, rigid, and Orwellian bureaucratic worst. The plaintiffs in this action were engaged in selfless, dedicated, charitable activity. This is the judge writing it, not me. This wasn't my case, by the way. They gave of their time and themselves to assist those in need. They received no personal gain other than the satisfaction derived from the charitable endeavors. The compassionate federal government, and particularly the well-known, warm-hearted Internal Revenue Service, has chosen to reward them with personal liability for the non-payment of withholding taxes. In addition to the primary claim for substantial taxes due, plaintiffs have been required to incur and pay substantial amounts for legal fees to reverse the liability imposed upon them for such taxes. So this is, again, they're being assessed individually. As stated at the outset, the court denies plaintiffs' motion for summary judgment, meaning that all the facts, the plaintiffs, the individuals, said all the facts, there's no facts in dispute, we win, judge, you rule, without the trial. And then, so the judge, they didn't want to reverse it with great reluctance. Humanitarian concern should spare these plaintiffs not only the payment of the money claimed, but the anguish and expense of establishing that they are not and should not be held personally liable for those debts. Although the law confers upon the government the right to pursue these claims, again, 100% penalty, neither the public conscience nor policy mandates that it do so. The court recognizes that its failure to grant summary judgment in this matter will add considerable to the financial burdens of the plaintiffs. The trial of this matter will be costly and time-consuming. No matter what the court's views of this litigation may be, it cannot ignore the standards imposed upon it in connection with the motion for summary judgment. If there were an appropriate way to resolve this matter without the necessity of a trial and the emotional and financial expense incident thereto, the court would have done so. However, the dictates of the summary judgment rule preclude the granting of the relief sought by the plaintiffs. It is unfortunate, I love this line, it is unfortunate when honest acts of charity are punished and so many illegal acts of greed are not. That's a judge writing that. So 100% penalty cases can be very, very difficult. Can be very, very difficult. Okay, so here. You get the audit, you go through the audit, it's not an eggshell, it's none of those things we thought, so you're the CPA, you're finally getting to the end of the audit, and the examining agent is proposing, say, an additional assessment because they found something wrong. What do you do? What do you do? Well, you have appeal rights. Okay? You could go to the IRS appeals group. IRS appeals is an administrative body above the examination unit. And they are manned by, they can be CPAs, they can be lawyers, they can be both, they can be neither. But they're supposed to be neutral arbitrators, so they're paid by the Treasury Department, but they're supposed to be neutral. So what they're supposed to do is they're supposed to take the administrative file and they are supposed to make an independent evaluation of the case. They have a lot of autonomy, so that if they think the case is 50-50, they can split it. If they think it's 80-20 or 20-80, that's what they can do. They can cut penalties. So if the 20% accuracy penalty is in play, they might say to you, we'll take 5%. I've had them take 4% on some of my cases. They can do all of that, and that's what they're supposed to do. They're supposed to make independent judgments. In fact, they settle upwards of 95% of the cases that come to them. The reason being the service cannot possibly litigate all the examination appeals. So what you do is you're going to file a protest. If it's under a certain amount, it's more a summary protest. If it's above a certain amount, they want a more detailed protest. But in the end, you're going to get a hearing if they ever go back to work with somebody who will listen to it independently. Not all CPAs want to do these appeals. I've taken CPAs into some of these meetings with me just so they can hang out and watch and learn. But a lot of CPAs don't want to do it. They just don't want to do it. By the way, is it a good idea at the examination level to bring your client with you? What do you think? Yeah, it's a terrible idea. It's about the worst idea you can do. In all my years of doing this, all my years, and again, I only get involved in some of the more hairy cases, but in all my years of doing this, I only once, I never like to say never, I once took my client with me. Once. You know why I took my client with me? Because my client was so stupid that there's no way the agent could have believed what they thought he did. Just too stupid. How about amending returns? So now you're under audit. Do you amend the returns? Again, probably a terrible idea. Probably nothing good can come of amended returns because all you're doing is making admissions. You're admitting to the amount, you're swearing under penalties of perjury. It's generally, again, I never like to say never, but it's by far a terrible idea to amend returns into an audit. Terrible. If you're going to do it, you better have a damn good reason for doing it. But you're going to get sued. You're going to get sued. Remember I tell you, the client always claims the accountant first. It's just the nature of things. Clients always blame the accountant. Now, Form 872, anyone know what Form 872 is? Form 872 is a statute extension. The service has a public policy. They endeavor to complete audits within the 3-year statute of limitations. That's the general rule. There are ways to extend it. You'll learn that in your procedure class. But generally, it's a 3-year statute. That's their public policy. So if you're under audit, they try and do everything within the 3-year period. There's sometimes, if not most times. I guess they, for the most part, get it done within 3 years, but not always. So they're gonna come to you and ask for a statute extension. And the question is, do you give it? There are several different types of statute extension forms, although most people don't realize it because the service generally tries to use only one. The one they use is a plain 872, which basically says, it's a contract, it's read by the courts as a contract between the client and the IRS. And what it basically says is if the statute is supposed to end on April 15th, 2019, by agreement of everybody, the client and the IRS will extend the statutes to some date in the future. And it could be any date in the future. It could be December 31st, it could be 2 years later, there's a lot of ways it can go. But and it keeps the statute open so that the audit can be completed or you can go to appeals. And I often get this question, do I sign it? There are other types of statute extensions. The one that I have sometimes used, not always, but sometimes, is called an 872A. And what that basically says is you sign it, the statute stays open forever. No expiration date. So the question becomes, well, why would you sign that? And the answer is because it gives you control over the statute. You can terminate that form by giving them an 872T. That terminates it within 90 days. So if you don't like the way something's going on, you can give them a termination form. So you can control the statute where you can't control it once you sign it. So if I give somebody a statute extension for, till December 31st, that's the deadline date. That's the drop dead date. I can't change it. But an 872A gives you more control of the statute because you can terminate it in a 90-day period. There are other kinds of consents the service doesn't like. There are restricted consents where you keep the statute open, but only for like one issue. So if it's car expenses, say, you can keep the statute open by putting it on a form, a restricted consent form, to just car expenses. Service doesn't like to do that, so they give you a hard time if you try and do it. Now, if you don't sign the statute extension, what happens? Suppose and now, by the way, under the Taxpayer Bill of Rights, they got to tell you in a form that you're not a bad person if you don't sign it. So years ago, it was kind of like, well, you don't sign it, you're a bad person. What do you got to hide? The answer is now they tell you in writing that it's your right not to sign it, and no one's going to hold you, as a bad person. The question is, why would you not sign it? Okay, why would you not sign it? And the answer really is, if the IRS missed an issue for some reason, and you give them more time, or there's an eggshell audit going on, and you want the case away from the agent because they haven't found the bad item yet, you might not sign it, or you wouldn't sign it. And the answer really is, what happens if you don't? Well, the agent may say to you, well, I'm going to strip the return, and instead of $20,000, it's going to be $2 million. And the answer is, who cares? Why do I care? It's out of your hands, agent. And the reason is that because when you go to appeals, you get all your appeals right, you can then show whatever receipts, or do whatever you need to do to knock the number down to a more realistic number. So a consent can be used to take the case away from the revenue agent. That's one reason lawyers don't sign them. There are a lot of reasons not to sign them. And before you sign them, you should consider all of these factors that go into this. There are times we will sign them. If the case is winding down or they just need an extra couple of months to go to appeals, it's possible we would sign them, but this takes a lot of consideration. Because once you sign it, you can't back out of it. So signing 872s and not signing them has a strategic viewpoint to it. Now you're in appeals, okay? And appeals is considering your case. Remember I said to you, appeals offices are lawyer maybe, CPA maybe neither, maybe both, you don't know. It's doing this independent. You're going to go in there, and you're going to present your proofs to the IRS appeals officer. Okay, you're trying to get a settlement out of them. It's a very informal process, IRS appeals. There's no transcription. Nobody's recording anything. He's taking notes, but it's really very informal. You're in a conference room across a table, and you're just bantering back and forth to see where you come out. Again, IRS Appeals has a lot of jurisdiction, has a lot of autonomy to do different types of settlements. You know, if you think that it's not worth litigating because the money is not big enough, you know, and 50-50 may settle it, then that's what you do. And maybe IRS Appeals settles it that way. You know, but basically they're taking an independent look at it. What happens if you can't settle your case in appeals? That happens sometimes. I said they settle about 95% or so of the cases that go into appeals, not all settle. You get what's called a notice of deficiency. Everyone know what a 90-day letter is, a notice of deficiency? 90-day letter gives you 90 days to petition your tax court for a redetermination in tax. It's what's called a ticket to the tax court. And the IRS will, or that notice of deficiency, will set forth the items they think are deficient, and they're proposing to make an assessment. Most people wind up in the tax court because it's a prepayment form, meaning before the service can make the assessment and come collect, before they can do any of that, you have to have an opportunity to go to the tax court. So the prepayment or the non-prepayment, as I said, is generally a very big inducement to most people, because if it's $1 million deficiency and you didn't want to settle at 50-50, it's better to have it heard in the tax court. Now, interest continues to run on this stuff from the due date of the return on the deficiency to the date of payment. So while you're in the tax court, interest will continue to run on whatever deficiency is ultimately determined. The other forms in the district court, which is a prepayment, you have to make the prepayment first and sue for the refund. And the same thing in the claims court, the old claims court, court of claims. You have to pay the amount and then sue back, which you'll learn in your procedure course. And that puts you in a different forum, but you gotta pay up front, which is generally hard for most taxpayers. When you get into the tax court, if that's where you're going, you're gonna get a lawyer assigned like me. And it's a formal proceeding in front of a federal tax court judge. The tax court at any given time can have between 25 and 40 judges. It's a national court, meaning it's stationed in Washington. And judges go around the country. They get assigned trial calendars. So they may put 200 cases, say, in New York. And 200 cases go in the calendar, and everybody gets advance notice. They say, a trial calendar comes out for 5 months from now, in June, say. You get notice that there's a trial in June. If you don't settle your case with IRS Appeals or the IRS lawyer, who has autonomy to settle cases also, you're gonna try your case in the tax court. And it's kind of like a hybrid appeals court, the tax court. In other words, you try your case, then you write your briefs. So in the tax court, you might try your case, then you write an opening brief, and generally a reply brief. And the tax court takes the exhibits, the trial transcript, and the briefs, and they write an opinion, which is, for some of you who may do research, you'll see these things as tax court memorandum, which are the cases with no precedent, or full tax court opinions, or the cases which have precedent. And that's how the cases get decided. So when you have an issue, the IRS has an issue, they have certain things they'll look for across the country. If they want an issue litigated, they'll send a memo around the country who's got the issue. And I've seen those in my days. That's how we used to do it, who's got the issue. And they'll decide who's got the best set of facts. The best set of facts for the government makes the best law for the government. So they can pick and choose, you can't. They might want to settle your case if they don't think the facts are that good and they got a better case in Hawaii, say. They might want to proceed with that case and settle your case. Again, the government has a national presence, you don't. You don't. And that's what happens in the tax court. And that's generally how cases will, get resolved or tried. And that's generally the procedure you'll get. I mean, obviously with more detail when you take the procedure course, whenever you do take that. Now, I just wanted, before I leave, I'm just going to give you 3 other pieces that are of interest, and then I'm going to open the floor to questions or whatever. I started to talk a little bit about the IRS private debt collection. That's a program that's currently going on right now. There's not a heck of a lot of statistics on it. The last thing I read, I believe there was supposed to be about 800,000 cases farmed out by the end of December to these 4 collection agencies, private collection agencies, of which Pioneer is one. And they have limited ability to do things, okay? They can't levy, they can't lien. The parameters of this basically are their cases not being worked currently by the service for varying reasons. The cases that are 53, which means that the IRS revenue officer or someone at the IRS has deemed them uncollectible. Again, there's $138 billion in debt out there, and there's limited IRS presence. They don't have unlimited funds, so they kind of like pick and choose. They have to kind of pick and choose what they want to collect on. You know, who's the best target, that kind of stuff. Who can we get the money out of? And so private debt collectors, as I said to open this, it's been tried twice before they lost money. This summer, the IRS came out with a report saying that they would finally turn the corner and they had made $1 million off the program. And I haven't seen much after that. I don't know what to tell you. Your client's gonna get a letter saying his name has been shipped off to Pioneer Credit, whoever it is. Pioneer Credit is gonna send a letter, and they're gonna try and put people on installment arrangements for the most part. And I guess the bottom line of this whole thing was, over the summer, I think it was, that Nina Olson, again, the taxpayer advocate, did a little statistical stuff on this. And at least according to her, the IRS was or Pioneer Credit and these other agencies was disproportionately collecting from the poorest segment of society. And probably the reason for that, at least I would surmise it, is that those are the people less likely to be represented. So they get put into, they essentially get put into installment arrangements that they can't support. In other words, someone calls you on the phone with authority, you get scared. And if you don't have a CPA like yourself as a buffer zone for all of this, they tend to do a lot of yes, yeah, I can do this, yeah, I can do that, and it's not feasible. So they have, at least according to Nina, a disproportionate amount of people paying from the poorest segment of society, which has been criticized. The companion section to this is the passport revocation. 40% of the American population has a passport. Okay? A couple of years ago, it's more than a couple of years ago now, Congress gave the IRS and the Department of Justice the power to revoke or not take an application for a passport. Okay, think about that for a second. How many people have passports here? Yeah. You try to renew it, and you get a letter saying can't renew. So when these collection notices, and the threshold is $51,000, by the way, 51 grand, tax penalty and interest, and it's set to a cost of living each year, but it's $51,000 right now. So if you get a notice, I don't know, somebody's texting me, Jay, it's not you, is it?
Not me.
So you get a notice with your bill that says, oh, by the way, you have serious delinquent tax debt, and we're turning your name over to the department, the State Department, and if you try and get a passport or try and renew a passport, you're out of luck. You're going to get a bounce. That's pretty tough, and it's really very tough. So, what's the remedy for all of that? Well, the answer is the government wants their money, again, this $138 billion in debt that's out there. So they're inviting you in to come in and do an offer and compromise and installment arrangements, all kinds of fancy language. But what it really means is you got to come in and make arrangements with the government to pay. And according to the government, at least over the summer, they were doing quite well. They had somebody come in and pay $1 million, according to them. Now, as of the last thing I read, they had not started to revoke passports, but they have the power to do it. So right now, as it stands, it's an application for a passport or a renewal of a passport. But they do have the power to revoke. And I don't believe anyone knows quite yet when they're going to exercise that power, if at all. So if you are leaving for a job to get, to go overseas, and you try and renew your passport, you might get a very bad surprise. Could be a bad surprise. And so the IRS says in those circumstances, call a letter on the form and work it out. They want you to come in. They want you to come in. Now, there are a few exceptions to this. They're narrow, like someone serving in a war zone or under 18, that kind of stuff. But essentially, they're saying to you, come in, cut your deal. They want you on an installment arrangement. Which brings me to another piece. If you go on an installment arrangement, you're the ones who negotiate. I do very few of these because most of the CPAs will do this. I don't do them for the most part anymore. But if you go on an installment arrangement or agreement with the IRS, you have to be able to stick to it. If you don't stick to it and they default you out, the second time trying to get it is generally much harder. Okay, generally much harder. Because there's a lot of reasons. One, you didn't keep your word. Two, they don't want to have to use resources to follow you. Once you get into the system, they want you to pay that monthly payment until you're done. And they don't want resources chasing you down. That's why you see in Philadelphia, they have an ACS, an automatic collection service. It's easy to collect with a 50-cent stamp. Basically, the letter's coming out of the service center saying you owe it. There's a reminder you owe it. Then there's a third letter, notice of intent to levy, and then there's a fourth notice. Because they're trying to get you to pay. It's easy to do it with a 50-cent stamp than to have to hire a GS-11 to track you down. It's more expensive for individuals. I saw a statistic. I've seen this in various forms over the years, but I once saw a stat that said for every dollar the service pays to a revenue officer for collection purposes, they get 7 back. Well, why would you hire a lot of them? Because it's not good publicity. Because if you're running on that platform, and you're on the side, the Democratic Republicans, and my client is out to fund the IRS, and revenue officers come and harass or collect. It's not politically expedient. But that's the reality of it. So again, if you're going to put your clients into deferred payment arrangements, you really should be sure that they can keep it, that there's a reasonable possibility or probability for that matter, that they will be able to continue the deferred installment arrangement without defaulting. Because again, you go in the second time, much harder to get it done. Much harder to get it done. Okay, I've had people come in with 3 or 4 defaults, and when the revenue officer shows up, it's very difficult. There's really only, there's only a limited amount of ways you can negotiate debt with the service. One is to full pay it, one is this installment arrangement, one is a bankruptcy, and one is an offer in compromise. So an offer in compromise is what you see on TV late at night when you're channel surfing. They have like OmniTax and all of these low-level, bottom-feeding groups that pick up these cases. And an offer in compromise essentially says, look, government, I can't pay $20,000. It's not possible. I'm 92 years old. I'm on Social Security. It's not possible. So the service has, over the years, devised a mechanism for taking less on the dollar than the $20,000. So if you're a business, if you're a CPA in business, and a client comes to you and he owes you, $1,000 for a return you prepared, right? And he can't pay it, you may say, okay, I'll take $750, let's call it a day. That's not how the government operates. They don't operate necessarily like a business. So over the years, when I started out in private practice, it was virtually impossible to get an offer in compromise through. It was impossible. They took so few in the state of New Jersey that it wasn't worth putting them in. There were complaints about that, so over the years, the service has opened up the program considerably. But in opening it up, they also made it somewhat difficult at the same time, because what happened initially is I might get a client who's a doctor, right, making $1 million a year and living in some mansion somewhere. And he was paying $15,000 to $20,000 a month in mortgage expenses. And he had, the fancy car with the big leases. And he had his kids in private school. But he owed the government a considerable amount of money. So when we do the 433As, those are the financial forms that everything is based on. We might, years ago, have put down as a necessary living expense private tuition, high school tuition for the kids. And sometimes you could get those through. And there were howls of discontent.
If you have to disclose that, is that optional?
Well,
that type of.
I'm gonna get to that. You get howls of discontent because someone 4 states away couldn't get it, or even somebody in New Jersey with a different revenue officer couldn't get it. So everybody was not treated equally. So the government turned around and they came out what was called national standards. Okay, true story again, I have a revenue officer in my office. Again, this is when I was starting out in private practice. And I have a doctor. And we're going over the 433A and I'm showing him all the substantiation. Again, that's the financial disclosure forms. And I'm showing him all this substantiation. And he turns around and he says to me in my conference room, Bob, my kids don't go to private school. I don't drive a Jaguar, I drive a Chevy. Tell your doctor to drive a Chevy, a used one for that matter. So again, the standards were kind of haphazardly done. So the service came out years ago with something called national standards, where they allow only a specific amount for a specific area in terms of rent. So you're not getting a $20,000 mortgage as a necessary living expense. And an orphan compromise basically says, you know, here are all the assets I have. If the government levied on them and sold them, what would they get in private auction? That's a number. And then they take your average monthly income, unless your necessary living expenses, they come up with another number. And through a bunch of gyrations, they combine those two numbers, that's your offer amount. So that's what you see on TV. You know, I owe $20,000 to the IRS, but they settled for $1,500 or something like that. That's how the government does these offers. But the bottom line of this whole thing is that again, if you're gonna put your clients in installment agreements, you have to be pretty certain that they're gonna be able to live up to it. Because if you go in and go out, it's gonna be a lot harder the next time. The service came out with CDPs, you know what they are? You probably wind up doing them, collection due process appeals. They got set up to, you know, if you get a notice of levy, you get the last letter that comes is this notice of intent to levy, or however they word it, and your rights to an appeals hearing before an appeals settlement officer, so that you can, you know, you have 30 days to submit a protest, and there's this whole gyrations you'll see on the form. But you'll get to an appeals settlement officer who'll try and work out some sort of arrangement. But you have to do these deferred payment arrangements. That's what the service wants you to do. They want you into the system. So again, the passport is, again, the idea they want you paying. And they have steps that you can do. You actually now have a tax court appeal, a judicial appeal. If the service certifies the debt to the State Department and they're in error, you can go to the tax court. They're very narrow standards for this stuff. But the bottom line of this whole thing is they want you to come in and be on an arrangement of some sort to get paid. They don't want to see you again. They don't. Once you're in, it's like the F-boss. Once you're in, they don't want to see you again. Once you're into the installment arrangement, they don't want to see you again. Okay, so the revocation of the passport's a big thing. It's been going on the last year, just about a year since it started picking up. And now it's pretty hot and heavy. So you may get clients who get sucked into this. So you may get those calls. And the last thing I'm going to end with is New York, because I've started seeing this a little bit more. New York several years ago went to a revocation of driver's licenses. $10,000 tax penalty and interest, not a heck of a lot. They will revoke your driver's license, or a New York driver's license. So, what does that mean? By the way, the passport is 90 days. You've got 90 days to straighten it out with the IRS. That's the period. New York, it's 60 days, 10,000 tax penalty and interest, 60 days. You're gonna get a notice. And again, the same idea. They want you to come in and get on a payment arrangement. There's no hardship exceptions in New York. It's interesting, the law got rid of no hardship exceptions. But it's 60 days to come in. If you don't come in the 60 days, they take the case, it gets shipped to the Department of Motor Vehicles, a godsend if ever there was one, to go to, you know, Brooklyn Motor Vehicles, my old hangout. It's about as bad as you can get. That's pretty big. I mean, it's just terrible for the lines and all that. And I don't have to tell you about motor vehicles, but motor vehicles is then going to ship out a notice to you. You have 15 days to straighten it out, or we're going to suspend. It's not revoke, it's suspend your license. It's not a revoke, it's a suspension. Yes, Professor?
You may not know this. I don't think you do, Bob.
Probably not.
You know who is the genesis behind that role?
Please tell me.
You're
You?
looking at him.
You know,
Because in 2008, I wrote an article.
one big boo, I think, is in order.
2008, I wrote an article about, I got this notion, because I had learned about stripping people of their passports, but constitutionally, that can be a problem, because they're gonna challenge that, because in the Constitution, there's freedom of travel. So, I am not so sure if and when someone challenges the passport revocation, if that's gonna withstand judicial scrutiny, so that's.
Well, I will tell you, there is some case law in this, and I will tell you something else. Various states, there's like 10 of them, I think, the last time I looked, they have some sort of variation of the New York rule, where they will do something with your driver's license.
Driver's license is different, that's a privilege.
Yeah, passport
It's
revocation,
a
you're right.
constitutional
Yeah.
right. So, I wrote this piece in 2008, and my friend Joe Bankman at Stanford picked up my piece, and California was the first state to institute stripping people of their driver's license. And then New York picked up on it, and New York has raised a few $100 million each year as a result of people paying up because of the risk of losing their driver's license. If you Google my name and put it in New Jersey, I have an op-ed in the Star Ledger about a year and a half ago, and we tried to get Chris Christie to sign on board and strip people of their license in New Jersey to raise some revenue here. Needless to say, New Jersey needs the revenue. Chris Christie did not sign on to this, but my hope is at some point New Jersey will follow suit. So I'm just sharing with you, I'm a little biased when it comes to this.
As I said, I believe the last time I looked, there were about 10 states that had a variation of this, but there are other states.
Oh, by the way, one other thing that
Does your professor, do you interrupt him all the time?
It's okay. I'm trying to give you, you know where
No,
this
I'm
all,
just kidding.
you know where this all started, actually? I was having lunch and people were talking about, you know where people do get stripped of their rights to drive is in matrimonial actions for child support. That if you haven't paid your child support, that was the starting point for people losing their driver's license. So I thought, gee, maybe we can extend that to the sphere of people who haven't paid their taxes. So anyway, just want to give you a little
No,
background.
and that's very interesting, I didn't know that, but there are other states in the Midwest where you can lose a hunting license
Yep.
for not paying your taxes. There's all kinds of strange machinations out there that other states have gone to. There are states that have various restrictions on your professional license if you don't pay your taxes. So for example, a few years ago, Mario Cuomo tried to decrease the $10,000 threshold to $5,000, and he also tried to make it applicable to professional licenses. So, for example, theoretically, it was possible had he gotten this through the legislature, $5,000, you can't be a CPA. So that was out there. And I think the last stat I had seen last year was that they've collected over $400 million right now.
Yep.
Under this program. So it is a tool they've used. Now, New Jersey, as I understand it, and again, I could be wrong, you want to comment? That's fine. The reason that you may not want to do it is that New Jersey was scared, as have other states, that people would be driving with suspended licenses, which is a consideration. So there are lots of viewpoints on this, that it's not that simple. But again, states need the money. You saw what happened with New Jersey Amnesty, state, New Jersey, the New York. These states need money for the programs. And so they're always trying innovative ways to try and get the collection going. And passports or driver's licenses or private debt collectors, that's all in the cards. New Jersey's had pioneer for a very long time, a very long time. So again, as I tell you, if things you're going to remember, the three people that you're going to see most at the IRS, the revenue officer, the revenue agent, and rarely, but it does happen, that special agent. The IRS, again, I come from the IRS, so I know it's a difficult job, and it has its rewards, but it's a very difficult job. So they're just people trying to do their jobs. I think I'm done, Professor, unless you want to hear more. So.
Does anyone have questions? I mean, you're talking to one of the foremost experts, so if you guys have questions, please ask, go to the source. Anyone have any questions for Bob?
Being that Pioneer Credit is hired from the state of New Jersey or the IRS, in this case, the state of New Jersey, I've seen that they, when they send the notices, it starts off with state letterhead. Is that legal?
They're hired by New Jersey. I never really have seen the letterhead. I've repped people. My understanding is they keep a state of New Jersey person on premises there.
Okay, to make it somewhat.
Well, they go for advice with these people. They're a delegate of the state of New Jersey, so again, I don't know what their letterhead looks like, because I just don't do it. I try not to get involved. It's more an accountant role. First of all, the reason that a lot of lawyers, especially in a big firm like my firm, we're just too, expensive on an hourly basis to have somebody pay us when they can't pay the government. So for us to get involved, it's gotta be fairly significant dollars. So mostly it's the CPAs who do this stuff. Now I get calls from the CPAs all the time about questions, what do I do, or how do I address it, or, what are my steps, what are my options? I got a call from a lawyer this morning who I was on the phone with for a very long time about options for a client that has fairly significant collection issues with the IRS. But that being said, again, you go back to the ways you can address debt with the government. You often compromise the bankruptcy. By the way, employment taxes are not dischargeable in bankruptcy. So if somebody comes out with this responsible officer stuff that we just briefly touched on, that is not dischargeable in a bankruptcy. That's going to stay there. There are income taxes under the right parameters that will be dischargeable, but employment taxes will not be it. Those trust fund taxes are not dischargeable in bankruptcy. So, these are all options clients have to consider. Trust fund taxes are very hard. They're very hard because, as I said, most people really need to put it back. But if you have to pay your employees and you got to pay your inventory and your trucks and all of this stuff, the easiest way for them to reach is for those trust fund taxes. The problem is when it doesn't get paid, the individual clients get credit for it on their income tax returns on April 15th. It's the government that gets left holding the bag on these. And they view the reach for the trust fund taxes as a very bad thing. And probably for good reason. Now, it's interesting, about a year ago, there was a conference call where the government came out and said they wanted to see more trust fund prosecutions. And trust fund prosecutions, at least in my judgment, they're gonna do them, they're looking for, as a threshold, the higher dollars and the toys. I call them toys. So what that means is that if the client is in essence reaching for the trust fund taxes so that he can buy a boat and go on, Long Island Sound in the summer, or take nice vacations down in Florida, or whatever they're gonna do with this, those are the toys, fancy cars. Those are the toys that the government should prosecute, frankly, if it's really abusive. I mean, it is wrong, but they have to choose the cases that are, make the most sense. You cannot prosecute, you can't possibly prosecute everybody, it's just not feasible. So they have to pick and choose, so they need their own internal parameters as to what constitutes what they want to prosecute. There's a concept in this area of when you're in business, and again, you're gonna see this all the time when you get out in the business world. You'll see clients that don't make the trust fund payments. And so there's a concept out there called pyramiding, which is the viewpoint that if you do this from quarter to quarter to quarter, you are pyramiding. So the IRS will try and close a business down that does that, because all they're doing is running up a debt. So if it's 2016 and I'm behind on the first quarter, taxes, and I do it in the second quarter, the third quarter, the fourth quarter, and I keep going into 17, and I'm doing it direct, that's all pyramiding, and that is what the IRS should shut down. Because if you're doing that, you're operating on the government, and maybe you shouldn't be in business. And back when I was with the government, that was a tack we took with our personnel. When we were directing IRS revenue offices, that was our viewpoint on this stuff. It just was our viewpoint that if you're pyramiding, you should not be operating a business. just the way it is, just the way it is. All right, so I'm done. I went probably longer than I should have.
It's always good to hear your voice and hear your insight. So, guys, thank you, Bob, for coming today. We really appreciate it. And if you have questions, always feel free to reach me, and I'll reach out to Bob. But he can be reached if you, Bob Stern at Sills Cummins is one of Newark's and New Jersey's largest law firms. So if you ever have a tax procedure question or a criminal tax issue, Bob is my go-to source.
And I'm always happy to answer questions. In fact, when I did this class last year, I got 2 calls, during the course of the next couple of months. There were CPAs with clients who had issues. So, as I said, I'm always happy to help people. It's not a big deal to me. Even when I was with the government, I was happy to help people. I often got calls when I was an IRS lawyer. I litigated a case against somebody, and a year later, or 6 months later, even 2 years later, I get a call and say, Bob, this has nothing to do with the litigation, but I have the following problem. What do I do? Where do I belong? Who do I contact? I was always willing to help people.
He's a good, Bob.
I did ask you before about whether they are obligated to report private tuition on a 433A. Is that if they have to disclose?
Well, when you look at the form, it's going to ask for, they're gonna ask for your checks, the last 3 months of checks, or even 6 months sometimes. So you're verifying all the items on a 433. There's nothing that you're making a full disclosure. So when you do a 433A or 433B for a business, or you're doing an offering compromise where you're using their forms, you are bearing your soul to the government. You're telling them about every dollar that's earned and every dollar that's being expended. And they're analyzing that form. I could take that form and tell you basically what their offering compromise number is. When you have houses, they may ask for an appraisal of the house. They can levy, by the way. You can't have your residence levy. You have to be very careful with this stuff. Back in my day, we took the position that just a piece of paper, an IRS administrative levy, would take the house. There was a big outcry over this stuff because it's so personal and so public that it became a lot harder over the years. There are rules for doing this now. They can foreclose on a piece of real property, especially where it's half owned by a wife and maybe just the husband has the debt or vice versa. There's very stringent rules for doing this, which didn't exist back when I was doing this stuff. So, again, I caution everybody, read. Go read the forms. And again, you're the first line of defense for your clients. You screw up, your client could go to jail or could have a significant liability. Not all CPAs are good at audits. A lot of CPAs are good crunching numbers and doing tax returns or being internals, CFOs or something like that. Not all CPAs are good at audits. And it's true of lawyers also. Like it's a long time since I did wills. I don't do them anymore. Not all, if you come to me, I'm not doing a bankruptcy. I'm gonna send you to another department in my law firm, or I'm gonna send, if you come in with a, buy-sell agreement on a piece of real estate in Paramus or something like that, I'm gonna send you another person. I don't do that. And it's the same thing with you guys. So you have to be careful not to go outside the realm of what you know. I'll end on this note just for the heck of it, because when the IRS changed the FBAR, when they started doing these programs and these machinations, a lot of the CPAs stepped into the shoes of trying to do the program cases. And so we saw a lot of CPAs doing this stuff. And what I used to say at audits, not at audits, at lectures sometimes was, when the service went July 1st, 2014, where you had to make a choice, you reached a fork in the road. So your client came in, he had the overseas account, and there was a fork in the road. And the question became, did you put him in the streamline, and did you put him in the full program? Okay? The CPA was trying to make that decision. And what I suggested to the CPAs in some of my lectures was, are you practicing legal advice at that point? Are you being a lawyer when you take the facts and you are making a determination that you can sign this certification for 5%, as opposed to putting you into the full-blown program where you're going to get much more criminal protection? Are you in fact making a legal advisory opinion at that point? And if it goes wrong, again, because once you went in one direction, you couldn't go back, and vice versa. So if you went in the program, you couldn't go in the streamline. If you went in the streamline, you couldn't go in the program. If you made the mistake at that fork in the road, because you were out there advising the client, have you now practiced as a lawyer? And you now get sued for that decision if it blows up? Just things I suggested. I mean, and you know, and again, I saw CPAs doing this. And, you know, they were trying, I suppose the idea was it's a good paying client and there's money to be made. The question is always what happens if it blows up? Okay, you can't practice law. So again, you know, your professor did that, the client privilege, we talked about it. It's a dangerous privilege. You don't have it in a criminal proceeding. And I can almost guarantee you, I mean, I never say never, but I can almost guarantee you if a case goes criminal, IRS special agents are coming to talk to the CPA. It's inevitable, because they're gonna wanna lock you in. What did the client see? What did the client give you? Did he give you all the bank records? Did he give you all the investment records? What were you doing when you prepared the return? Were you looking strictly at the bank account and taking the deposits and using that as the gross income, when in fact he was doing half his business in cash? This is the questions you're gonna get, because they're gonna want to lock you in, as they should. If you're trying to make a legal case, they need to lock the CPA in, as I would have done, and as they should do, and as they do. So, you know, it's not easy. Being a CPA out there is not easy. I have a lot of CPA friends that tell me it's a lot harder now than it ever was. There's a lot more regulation on you guys, there's a lot more things to do, you gotta be very careful. Okay, gotta be very careful. So if anyone has problems, just call me. I'm always happy to help people, not a big deal to me. I don't always get to people the minute they call, because I'll be in conferences or whatever, but I'll always get back to people. It's one of the things my wife complains about. One more piece of advice: turn your iPhone off when you go to sleep. I used to keep my iPhone on, right, near my bed, and the thing would be dinging at 2:30 in the morning. I have a client with insomnia, and I'd be getting texts. And the thing with iPhones is that with these texts now is there's this expectation of immediacy. Is that right? Where they expect an answer that minute, and so you know, you don't answer a client in the next 25 seconds at 2:30 in the morning, they're upset with you the next morning. So my wife says, you gotta turn that off.
Save the marriage.
Save the marriage.
Right. And see, that's a good way to end. Save the marriage.
Save the marriage. But remember Sheridan if the marriage goes bad.
Sheridan, did I spell that right? Sheridan.
Sheridan versus Sheridan, it's out of West Jersey.
Yes.
A while back, all matrimonial attorneys are gonna know that case, or they should. If they don't, they're not matrimonial attorneys. They all should know that case. Because in a divorce, I am telling you, what comes out on the record when people hate each other is pretty amazing. It's not just Sheridan, it's all these cases. They all have components of this. So if you're gonna testify under oath to tax fraud, you're gonna get what you deserve.
Well, I think the first recommendation is don't get divorced. Right?
I think that's a pretty good recommendation. Good
Keep
luck
the
to you
peace.
guys. I hope you all do well as CPAs.
All right, thank you again, Bob. We really appreciate you coming in and spending it. I'll give you Bob's contact information after he leaves, or I'll circulate an email. I hope you don't mind, as long as you turn off your phone, I'll circulate your email. And
Take care.
all right, take care again, Bob. All right, guys, so you just got a taste. I mean, Bob really knows his stuff. He's done a lot of this. And I mean, the good thing about hearing from Bob is just that he's going to echo a lot of my sentiments, some things that you've heard. And it's never bad hearing it from me, but who am I? But maybe if you hear from him and you hear that echo chamber of sorts where you hear from both of us, you'll be like, oh, there must be some credibility there. So, and if you do have questions you want me to run it by him, let me know. He's handled as many cases as virtually any other attorney in New Jersey on tax matters. So he's a go-to resource. And I just worked with him on this most recent case where people failed to report their overseas account, and the Department of Justice now is deciding whether or not to criminally prosecute people like our clients. He just took a trip down to Washington, and we'll see where this plays out. All right, so let's just pick up where we left off. I'm on page 100. We talked about the AICPA and conflict of interest. And I said to you, number one reason you'll hear it, there are different attorney is conflicts of interest. Whether or not Circular 230 also affirms that you shouldn't operate with a conflict of interest. Query whether or not Circular 230 applies anymore because of Ridgely and Loving, but it's something we should consider. So look at problem 3-1. As usual, Peter, the thermostat's down.
Yeah.
It doesn't seem to matter, but it is warm up here. It's warm in the entire room. Problem 3-1, we have X is the president, chief executive officer of family-run corp, small family-run business. Family-run engages practitioner to prepare tax returns for the company, its officers, and its shareholders, all family members. And I mean, I would imagine many of you in this room, right? This is a common scenario, right? Nick, you represent families, right? And the business and everything, right? And you're happy, right? Everyone's happy, right? It's like not one client, but 10 clients, right? Because you get the business, you get the shareholder, you get all the family. That afternoon you're bringing out the champagne bottles. But as practitioner prepares family runs return, there's a question whether or not the payment the company made to X is deductible payment is a compensation or a non-deductible distribution. Does practitioner have a conflict of interest? If so, can it be cured and how? So distributions, now assuming it's a C corporation, right? C corporation, it could be compensatory, or depending on the so-called earnings and profits, E&P, of the company, that's code section 316. I'm not holding anyone accountable for subchapter C, but there's different ways that distributions from a corporation can be taxed, and it can have a bearing on future liability of the company. It can have an immediate bearing on how the shareholders are taxed, and there can obviously be a potential conflict of interest, okay? And the potential cure to that potential conflict of interest is, throw it out there, Brian, what would be the cure?
Substantial authority.
Remember, we're not talking about tax return preparation now. We're talking about, so don't invoke substantial authority, Gus, right? What would you invoke?
Client disclosure.
And getting a waiver, right, Brian? And because substantial authority doesn't have anything to do, we're not talking about a reporting position here, right? We're talking about between and among your clients that there may be potential conflict. You want to make sure that if someone feels shortchanged, they don't go for your neck, your jugular. Because if they feel shortchanged, and they think that you were the person responsible, right? Because you treated something as a distribution which was tax favorable to their brother, and damn it, they hate their brother now, right? They're gonna blame you. Because they can't, it's a dysfunctional family. They can't blame the brother. Maybe they'll blame the brother too. I mean, I'm dealing with 2 physicians now, and they're brothers, and if I had them in the same room, they could not be left alone. I think they literally would kill each other, all right? So you just have to be very careful. And I am dealing with 2 sisters now that I say it, and the verbiage, I represent one of the sisters. I mean, the explicatives that every time she mentions her sisters that leaves her mouth, you just can't believe that these people grew up presumably, as 2 cute sisters hand in hand, and now I'm sure they would kill each other, left in the same room. All right, so I routinely see that, and I can't believe she's hiring me to fight over tangible personal property that I can't believe is worth more than $30,000-$40,000, and to spend money, but I know it's driving her up the wall that her sister's taking more of the property, so it's worth, in her mind, every penny to aggravate her sister. So, all right, 3-2. Or I should say Q, A and B, all individuals are partners in limited partnership. A limited partnership, Q is a GP. Q engages practitioner of repair LPs 1065, and the partners K1. Practitioner is separately engaged by Q, A, and B to prepare their individual tax returns. By preparing LP's return, practitioner identifies an issue as to the meaning of a provision of the partnership agreement that will affect the allocation of partnership items to the partners. This provision can be interpreted to provide an allocation of certain tax benefits to Q to the detriment of A and B. Does the practitioner have a potential conflict of interest? If so, can it be cured and how? So some of you have had partnership tax, some of you are looking forward to the upcoming fall. So in section 704, you need something called substantial economic effect with respect to partnership allocations, and it can have a major bearing on who's taxing the tax burden. So there's potentially inherent conflict of interest. And I know what you're thinking, Brian, but I know what you're not thinking. You're not thinking anymore of substantial authority, you're thinking of what, Brian?
Disclosure and waiver.
Yeah, I mean, in this context, again, we're changing course, your mind is changing. This is not dealing with chapter 2. We've turned the page, metaphorically and literally, right? So, whole different, John, you were gonna say something?
Yeah, so you're allowed to tell a client like that you are also preparing someone else's return?
Absolutely, with the caveat that if they say, hey, I don't like this because you may be out for them or you can't give me 100%, then you have a conflict of interest and they're not waiving. They need their own counsel and you should get the hell out of there. And everyone should have their own counsel. So you put it out there, if they accept it, great. If not, this is one of those times you lose that client. You know, remember when you were dating in your dating days, John, and you said, or someone said to you, I'm sorry to say this, John, they said, lose my number? You lose that client's number. Right? Probably never happened to you. All right, but me it did.
So what I'm understanding is that if you have a multi-partnership, 2 or 3 people,
Right.
that it's straight from the beginning, it should be, you should figure out potential
Absolutely.
problems and then.
There's always going to be potential problems in fact, with
Well,
any
have it
partnership. Not today, tomorrow.
Right, have
So you
it
might
written
as well
down.
put it out there at inception. Don't wait for the problem to happen. Say, oh my God, there's a real conflict here. Do you guys waive it? That may be too late.
And have them sign it.
Absolutely. Right? And I shouldn't say this on tape, but I'll say it. What I did earlier in my career, I would have clients come in, and I figured, you know what? They're trusting me to do their estate planning or buy-sell agreement, whatever legal work they needed done. I wouldn't get a retainer letter because they trusted me, and it was kind of nice. They entrusted me, and I was pretty fortunate, and I wasn't so brave because I don't deal with big cases. So it's not like I had potentially $100,000 at risk of not being paid. And what you'll learn is what's the second biggest reason people get sued, not for malpractice. It's pretty obvious.
Errors?
Well, is when you sue a client for non-payment, the first thing they do is they countersue for you for malpractice. They're gonna say they're not paying you because you screwed up something. Doesn't always happen, but that's a very common parry. So my philosophy has always been, and by the way, when you apply, has anyone here ever applied for malpractice insurance? Okay. And you know, Ping, what's one of the questions they ask? Do you ever bring collection actions, right?
Yeah.
And I gotta believe, I don't know this for sure because I don't know what goes on. If you say yes, or you say routinely, or whatever, I forget how the credit, you know they're gonna charge a premium because they know you're gonna be sued, all right? If not today, tomorrow, right? So I'm just sharing with you that that I would not get retainer letters because I also knew I wasn't gonna sue anyone on it. It just wasn't, but I've learned, first of all, speaking of applying for malpractice insurance, malpractice carriers will not cover you now unless you get retainer letters. They all ask the question when you apply, do you get written retainer letters? And my broker said, hey, if you don't say yes, you're not gonna get insurance. And I knew if I said yes, I have to fulfill that commitment because if I ever do get sued, they're gonna say, we're not covering you because you didn't get the, so we now get retainer letters, and you might say, okay, how does that, but by forcing me to get retainer letters, it really, I know this sounds strange, you actually have to think who's your client, like who are you addressing the letter to? And it's a really good mental exercise. So in retrospect, I was an idiot, added to my list, of not getting retainer letters. But by getting a retainer letter and knowing who I should be addressing, it's been a very useful exercise. So anyone in this room, don't follow my old habit. Make sure you get retainer letters and try to really pinpoint who the client is. Because in a partnership like this, you may have multiple retainer letters going out. And you may have multiple disclosures where you want to try to memorialize that waiver all on one page. Problem 3-3. John and Michael were married for all of 2015. In June 2015, Michael initiated divorce proceedings. So I guess this wasn't the happiest of marriages if they got, well, we don't know when they got married, but they were married for the entire year, but then someone's initiating divorce proceedings. In early 2016, John engages petitioner to prepare the couple's joint 2015 return. Not long after, Michael, through his attorney, asked practitioner to prepare the 2015 return as married filing separately. When practitioner informs Michael's attorney that he was already engaged by John to prepare a joint return for the couple, the attorney informs practitioner that Michael has no intention of signing a joint return. Does practitioner have a conflict of interest? If so, can it be cured, and how? And I know, guys, we now know the drill, right? I mean, you cannot prepare a joint tax return for someone who has no intentions or has potential conflict of interest in doing so. And I am sure Brian will agree with me that we better get a waiver here. And we may or may not. And if you don't, you know the drill. You probably can't have either of these people as your client, or you can only have one of the two of them as a client if the other one consents. And I've been in situations where I have represented a husband and wife, and they get divorced, and the wife subsequently called me up and said, hey, can you redo my will? I said, I can, but I have to talk to your ex and get his permission. And what does the ex say? Well,
no.
This will make it easier on her, so now I don't want you to do it. So, but it is what it is, right?
So if they're legally separated though and everything's done, where's the conflict exist?
In
at that
theory,
point?
it didn't, but I could tell he was like gun happy, and he was so angry. I could tell that you're right, but it, like, I didn't want to endure potential where he, you know, if someone files an ethics claim against you, are you going to win? There's no
Give
winning.
me a win,
right?
don't win.
So what am I going to do? Get a $1,500 fee and get an ethics complaint and have to deal with that anguish? And again, on your malpractice insurance, the questionnaire will say, have you ever had an ethics complaint filed against you? So, and what do you think? You can win if that happens? You can't win. And I know people will say, by the way, there's a cliche out there that really bothers me, but if it hasn't happened to you, you might. How many of you will say, where there's smoke, there's fire, right? You've heard that cliche? You really got to think hard about that one, because sometimes, guys, there's smoke, but there ain't no fire. But people really subscribe to that cliche. It's a nice, easy one to lean into. So the fact that there's smoke does not mean in our practices there's fire. And that may happen to you, and just bear, you're gonna have to grit and bear, because people are gonna, even if the ethics complete's completely shallow, you know, people say, oh, there must be a problem, you know, with your practice, but there may not be. So just know, I've heard that cliche, and I really think hard about that cliche. Now, it goes with, you know, some of these accusations about different people. What is it, R. Kelly? You know, if one person says it, maybe there's no fire. It's when the 100th person says something, say, you know what? There may be a you know, a really, you know, vibrant fire going on out there. All right, 3-4. Accounting firm offers to discuss with June Cash a package of ideas that the firm says could significantly reduce June's taxes. Accounting firm will share the package with June. However, only if June pays accounting firm upfront fee for the information, and June and her attorney Rocky enter into a confidentiality agreement pursuant to which June and Rocky agree never to divulge the ideas in the package. And by the way, if someone's asking you or your clients to enter into a confidentiality agreement, what do? Run for the hills. Because that's probably what falls within the domain of being what's called a reportable transaction. So that's under 6662 capital letter A. That means that you have to report it, and once that one's gonna attract some real IRS scrutiny, okay? I can guarantee, why do they want confidentiality? And it used to be, there was no reporting requirement, and people did try to protect their intellectual capital by asking for this, but now that that's really, legally you're supposed to have a filing obligation, people don't do, in my experience, I haven't seen anything like this in 10 years. If Rocky signed the confidentiality agreement, would he have a conflict of interest in representing other clients who could benefit from the ideas that Rocky obtained from accounting firm but agreed not to disclose? So has Rocky put himself in a compromising position? Is Rocky now going forward with respect to his future clientele have a potential conflict of interest? And the answer is yes, because he may, assuming these are legitimate ideas, let's remember, that's a laconic if these are true. He's not able to share legitimate ideas with his clients. Would you feel you're being adequately represented if your representative knows of some tax savings idea? Let's say setting up a cafeteria plan under Code Section 125, and can't tell that to you? That's problematic. So if I'm Rocky, I think there's a real conflict of interest in signing, and that you might be violating your principles under the AICPA and the state licensing by putting yourself in this kind of position. All right? So these are things to think about. Remember, this is an ethics class when you get down to the very basics. You know, these aren't things that are black and white necessarily. These are things that are shades of gray. Kevin, were you going to say something?
No, I was stretching, sorry.
That's fine. So with respect to business planning, you know, something that comes up all the time is that clients come to you, they want to set up a new business, they want to set up a partnership, they want to set up a corporation. Should it be an S Corp, should it be a C Corp, all sorts of things. And when you establish a business, the authors of our textbook raise the question, query, who is your client? Who is your client? Is it the business, but the business hasn't been formed yet? Is it the individual shareholders or the individual partners? It's the chicken and egg question. Who are you representing? And in part, that's why that retainer letter can be useful. How are you going to formulate that retainer letter? Who's going to sign that retainer letter? Again, it's not because you're going to look to sue your clients. It just makes it easier to understand on whose behalf you're going to advocate. Because the footnote 4 on page 103 says individuals who form business often have inconsistent non-tax objectives as well. So it goes well beyond tax, right? Voting control or veto power over certain acts, a priority return on investments or security for loans. Conflicts also may present themselves in choosing the form of entity, establishing rules for internal governance, structuring financing, agreeing how to resolve disputes and negotiating exit strategies. All these things present potential conflicts of interest. Now, I know and you know, in most instances, clients appropriately see economies of scale by having you represent all the parties, right? They don't want to hire 6 accountants, right? Because they're going to say your fees are expensive enough as is. They don't want to multiply that by 6. But your objective is to make sure that they understand that you're not an advocate for any of them. You're going to just try to see it as it is to promote, let's say, maximize the profitability of the business. But there's certain decisions that they will have to make. You will not intercede in those decisions. And there's potential conflicts of interest. And that you are going to have them, and I always make clear, that you should seek separate legal counsel. In fact, in all my shareholders agreements, in all caps, I have that the parties understand that they had a right to separate legal counsel, and they have waived such rights. But that's the only provision in the entire buy-sell agreement that's in all caps, that CYA kind of language, all right? So, but it doesn't hurt, guys, because if and when you do get sued, you know, just give ammunition to your defense attorney, who will say, gee, the whole agreement is written in normal font. Why is this language? And you will put whomever is now suing you in an awkward position of, you know, did they not read the language that was all in caps? Was there something that drew their attention away from it? They can be made to look fairly foolish, particularly if during the course of the trial they're able to project that on the screen and show the members of the jury, right? So I know that sounds kind of, you know, life is tough enough, and I'm telling you, you got to practice from this silo of concrete defense, but it doesn't hurt to take all these measures. Even with all these measures, things can happen, but try to give yourself as many protections as possible. All right, so in the State of Bar of Arizona opinion, pages 103, 104, 105, there's several different questions that are being bandied about who you're representing with respect to a newly formed entity, business entity. Are you representing the entity? Are you representing the individuals? And what you'll see is there's no definitive answer here. It's going to vary from state to state. That there's nothing. This is not federal law. Let me emphasize that. Is that when we look at the Internal Revenue Code, right? That's derivative of federal law. Agreed? Title 26. That's, you know, I have the code in my briefcase, but you're dealing with issues pertaining to the code. When you're dealing with conflicts of interest issues, it's all state law, okay? It's state law, and it may not be statutory law, it's what we call common laws. What have various cases, what have courts decided? So speaking of being amorphous, it is amorphous, right? It's
Title 26 is state laws?
Oh, Title 26 is the federal code. Title 26 is the Internal Revenue Code. And what I'm pointing out here, when we're dealing with conflicts of interest issues, it's state law, but it's not state statutory law. State statutory law, for example, says you must be 17 to secure a driver's license, right? That's written in the statute books. When we're dealing with conflicts laws, whether you represent the aggregate or the entity, these are what's called common law theater, where judges write opinions, and that becomes operative of what controls going forward. All right? And that's why in this opinion, it cites to many cases.
And that's due to the fact that states control entities' formations.
Entities are dictated by states, not by the federal government. Okay? All right. So, on page 107, it refers to on page 107, the first full paragraph refers to a 1992 case, Jesse v. Danforth. The case referred to in the State of Bar opinion, the Wisconsin Supreme Court held that a client is the corporation, not the corporation's constituents. Okay, and it cites to a paragraph in there. But what's more interesting is the paragraph that follows the indentation, because in that case, the entity theory control. So it goes on to talk about the implications. Under the quote-unquote entity theory of representation, a corporate lawyer typically is not disqualified from representing the corporation in litigation between the corporation and one or more of its constituents. It also means that the corporate lawyer generally is not liable to shareholders, officers, or directors for malpractice or breach of duty. So it just talks about some of the implications. Let's look at problem 3-5, because then we'll get an even better idea of what's going on here. We have 3 prospective clients meet with lawyer to discuss a new business venture. A, who has experience in business, would contribute his management skills. B, would contribute a substantial amount of cash. C would contribute assets that could be used in the business. Each person would receive 1/3 of the stock in the newly formed corporation. A, B, and C have asked lawyers to create the corporation and advise them with respect to the tax and other issues relating to forming and operating the business. May a lawyer represent all three individuals seeking to form the business? Whom should lawyer represent in the case? How would you advise the lawyer to proceed? Now, just keep in mind, again, I am not going to test this for your exam, okay? I will not. But it doesn't hurt to remind some of you who've had corporate tax, and those who haven't had it, to give you a little foreshadowing of what's to come. This is traditionally known as a 351 transaction, okay? In the corporate area, in the partnership area, anyone here have partnership tax yet? And what is it called, partnership? What is it, this kind of transaction, formation of a partnership?
Tax equivalent.
Under what code section?
721?
721, right? Yeah, music to my ears. All right? So there's two, again, these are two code sections, just like code section 61 has to be like tattooed on your chest. Code section 351, corporate formations. Code section 721, partnership formations, right? Both are non-taxable, but 721 is a much lower threshold. Very easy to have a 721 transaction. By way of contrast, a 351 transaction, 351, what do you need to get to the promised land of non-taxability? You remember?
80%.
80%, Kevin, spot on. Code section 368, 368C, you need control. So you need to reach the 80% threshold, right? And sometimes it will be, but do services count? Like you need 80% of the people contributing property, but those who contribute services, does that count towards the 80%?
No.
No, that's code section 351D, only if you contribute both property and services, right? And the value of the property can't be de minimis. But let's pull all that aside, because again, I'm not gonna test anyone on their knowledge of corporate tax. You know, I know you guys want me to, but I won't, so I'll resist temptation. The point I'm just trying to make, Amari's breaking into a cold sweat because he hasn't had corporate tax yet.
Right.
Your number's coming up though, all right? So, but I will not test you, you can sleep tonight.
All right.
All right?
I appreciate it.
All right. So, my point is though, people could have different interests here because some people want tax-free treatment, some people who are contributing services are indifferent, right? Because they're gonna be taxed anyway, and some people want it to be taxable because they're contributing lost property, right? And if they're contributing, they won't get a loss, right? They wanna get their loss, and they can't get their loss. So, there's an issue here. Given all that, may a lawyer represent all three individuals seeking to form the business? And again, it doesn't hurt for the repetition. Of course the lawyer can, and this is a waivable conflict, right? Waivable. Now again, let me emphasize, some conflicts are not waivable. You cannot represent a husband and wife and say, gee husband, gee wife, you know each of you hate each other, but I'll try to do my best to represent both of you, and but just grin and bear that sometimes I'm going to be on one side of the table, sometimes I'm going to be on the other side. You can't put that in writing and say, see, they waived their conflict, right? Because logistically that just can't work or work right. So it's non-waivable. So before you work with an attorney and I've seen attorneys, sadly, who try to work both sides because now that they've got two clients instead of one, that doesn't work, and you don't want to be the accountant helping that attorney because you're going to end up getting sued. You were going to say, Viva?
Sir, same thing. If a husband and wife, they both agree to file tax return together, and after that, the husband, he don't want to share his information with the wife, is it possible that way or no?
Are they getting divorced or not?
No. Actually, suppose
That's not a good sign, by the way.
Yes, they file together. Now they don't want to share information to each other. How is it
Are
possible?
they getting divorced? And you're
Yes,
saying,
no, they didn't share that they are going divorce, but they are living separately, but they want to file together and don't want to share information together.
well, I wouldn't get involved. You know there's a problem there, right?
Yes.
Mm-hmm.
I mean, it sounds like they're at the precipice of blowing up.
They want to file separate, but when we are telling that if you owe this much money, this much, then they file together. And
Yeah,
then
but
why-
I just have a feeling that things are not looking too sanguine. That this is a marriage on loan, so it's, something's gonna happen soon, and when it does, chances are you're gonna be blamed. So, I mean, if someone's trying to seemingly put you in an awkward position, I know it's tough, you don't want that person as a client, I'm just telling you, not gonna turn out pretty. May your answer day change if A, B, and C brought in a quote-unquote another partner who contribute property with an adjusted basis in excess of value. Okay, can you represent D as well? If they wanna bring in another partner who would contribute property with an adjusted basis in excess. What do you know about that, guys?
Adjusted basis in excess of value.
Yeah, because
Yeah,
it's
but
against
but
the law.
there's a code section, this is about 10 years old now, code section 362E, that says that person cannot get, you know, again, they're gonna lose the loss on the contribution, and the partnership, or excuse me, in this case it's corporation, is gonna take a smaller basis in the property. In other words, how do I respond to this? If they brought in if they bring in a partner or a shareholder, the word partner is kind of weird, if you don't mind me saying. I think they mean shareholder in question B. You have to be careful because you gotta make clear to partner D or shareholder D that you don't represent his interest. I think you gotta just make that clear because D may be forfeiting a multi-million-dollar potential loss by contributing this property. If it's a tax-free contribution where if they had sold the property, they would have secured the loss. So, I think you gotta make clear to D, you don't represent, because if D subsequently finds that out and thinks hey, I thought you were representing me, and they lost a multi-million-dollar loss, who are they gonna sue? You. So you better go on record saying, I don't represent you. If a dispute were to arise among the three partners, one of them decided to hire her own lawyer, could you, meaning the original lawyer, continue to represent the remaining partners?
As long as you have it in writing and the consent of the others.
See, I don't think that's waivable. I don't think you can get consent, because remember, you represented the three of them, and now you're privy to information, right, about the original one, that you really probably, a new attorney wouldn't have about that person. You might be privy to information. I think you gotta withdraw. Like, you can't, let me also make a very blanket statement. You don't wanna be in a position where you're suing your former client on behalf of a new client. Suing your former client on behalf of a new client, people feel betrayed. Why are you suing? And I actually had this, call me, again, I keep saying call me an idiot, but, and by the way, I've heard this, that when it comes to lecturing, men can get away with this, where they say, where they're self-denigrating, but women cannot, because there's a different psychology where if women say it, people say, oh, she must be right. There's different studies on that. Anyway, enough about self-deprecation. I once said to one of my clients, someone wanted to bring me in as an expert witness in this partnership issue, and it was with a client I had 15 years earlier. They were gonna sue, and I don't know what caused me. I called up the client, I said, look, I've been asked to be an expert witness on this. Would you waive this conflict? I mean, this was a while ago when I asked this question. And they were very nice. They said, no, we like you. We don't want you to sue us. And it dawned on me, like, what was I thinking making that phone call? So I would say this, and I've seen it in other cases, you never, ever want to be in a position where you're the accountant or lawyer suing a former client. I don't care how many years ago that person was your client, not gonna turn out pretty for you, right? Because if you're very successful for your new client, your former client's gonna say, somehow, some way, they should not have played that role. You cannot win. Suppose that you accept representation in full compliance with your ethical obligations, and that several years later, A calls you to discuss renegotiating your salary. How should you handle her call? So one of the players here wants you to negotiate with the other people, and I think you guys know the answer. Do you want to play that role? Do you want to negotiate with your other clients? And the answer is no, right? You're not going to negotiate with your other clients, right? 3-6. You recently filed a letter requesting a letter ruling request with the IRS on behalf of Smithco to the effect that a series of contemplated transactions should, with the application of the STEP transaction, be treated as a tax-free reorganization, I presume under Code Section 368. Jones's has asked you to represent it in tax court litigation in a position which will be that of a similar series of transactions should not be stepped together, but should instead be treated as separate steps, with the result there is no tax-free reorganization. Can you take the case? So, on one hand, you're making a private letter ruling request saying something constitutes tax-free. On the other hand, you're taking what appears to be an identical fact pattern and arguing it in tax court. Is this the case you would want to take, guys? Aren't you fearful that if you take this case and win in tax court, you'll be subverting your position on the private letter ruling request, right? Because all of a sudden there's substantial authority for the government to decline your position. So I don't think you want to be at opposing ends in favor of one client against another client, right? So that's going to be inherently problematic. The problem continues. Would your answer be different if you were representing Smithco in tax court rather than in the ruling process? What is the answer if you were if you're representing Smithco in tax court rather than the ruling process? I think it's more problematic, because if you're representing two different clients with two opposing views in the tax court, I think you have some issues in the tax court about your credibility. But then again, depending on which decision is rendered first, you're gonna shoot the other client not in the foot but in the face. So I don't think you want to represent people with opposing point of views, particularly when those opposing point of views are apt to become public. What is your answer if you're representing Smithco connection with an audit after the transaction has already been reported as a reorganization on a filed tax return? So suppose it's already been done, and now you're an audit, you're saying that it should be tax-free. Is that problematic? I mean, by then, it's already been done, right? Remember, when you request a private letter ruling, that hasn't been done. In where you're being audited or your client's being audited, that has not been done. So, in this case, I think that's okay. Okay, because now you're just responding to something and you're trying to mitigate the client's damages. So I think that could be done. Let's just talk about, I know what I want to talk about. We got 5 minutes, so let me just talk to you about this paper, because time is not going to be our friend here. Let me just distribute out this notice. Let me just all right. Okay, hold on. Kevin, if you can, or We have more here. Does everyone have one now? Alright, so let's just talk about this. As part of this class, each of you will prepare an essay. As part of this exercise, you consider, I am your supervisor. You have met with one of my clients. I am going to shortly supply you with a short fact pattern. After you meet with my client, you should prepare a 3-page memorandum. The memorandum should outline the facts and issues. Once you provide this background information, you should then present your analysis. Not only should you present the ethical issues and the rules that govern, if relevant, you should also detail the potential penalties applicable to the taxpayer and the practitioner for being derelict in his or her responsibilities. Now, I am going to shortly, you're going to pick your fate. There's 16 of you, I have 16 different fact patterns. So we're going to hold it upside down and you're going to pick your fate. All right? Each of you have a different fact pattern. I point out this is not a group project. Your analysis and writing should be your own. So you're not supposed to share your thoughts. The paper should be double-spaced, 12-point Roman font, normal 1-inch margins not to exceed 3 pages. Do not go on the 4th page by 2 lines. Do not go on the 4th page by 1 line. It should just be 3 pages, okay? Unlike my somewhat tolerant exam policies, you cannot turn in a paper late without a quote-unquote very valid excuse. So let's not even go there. I'm gonna tell you next class when the due date is. Let me talk to Jackie Adams. You're gonna hand these in anonymously, okay? You're just gonna put, without your name, Jackie, or I'll have Kathleen, let me decide that next class, to assign a number to you, okay? And you'll just put in from, and you'll put in, if you're number three, and then you'll put in the essay number. And we'll go from there, all right? We'll talk about it on Saturday in more detail. Go ahead, V.
Some of us have Pacheski's exam right after Saturday's class.
That's okay. You don't have to start this. I mean,
Okay.
you can think about this. This is time for you to gestate. If you could, for next class, guys, let me just tell you before you leave me. We didn't get quite as far as I would have liked, but that's okay. We will survive. So if you could, let me just see where we're at. If you could finish chapter 3, that would be great. I don't know exactly how far we'll get, but if you could finish chapter 3, that would be great for Saturday. We're going to go the full 4 hours. And I'm going to distribute this. I think the weather on Saturday is supposed to be wet in the morning, snow in the afternoon, so I think we should be fine in the morning. If there's any issues, I'll send you an email or send me an email, but I think we should be fine for Saturday, okay? John.
Are you gonna give us any kind of like example or something like that to kind of go with it?
I don't have a good example, but if you have questions about how you should handle this, let me know. So anyway, I'm gonna just pick out one, not more. Pick out one, pick out your fate. This way I didn't do this to you. You did it to yourself.
It's dangerous.
People say they do better if they make choices as opposed to having the choice made for them.
I got that.
It's staring you right there. Gus, you want to reach over? Go for the top. All right. All right, we got one left, and that's for Andrew, who's not here today. So he has no choice. He's got to deal with the cards he's been dealt. I will be around. I will see everyone here on Saturday morning, okay, 8:30? Any follow-up questions, just let me know.